I'm going to just ask a few questions to Mr. Azmy, and it's my understanding that the Detainee Treatment Act process requires the court hearing a detainee's position to accept all of the factual findings of the CSRT panel. Is that correct?
That's right. You must assume you assume that the factual findings of the CSRT are correct, and under the procedure created by the MCA and the DTA, you're only really permitted to see if the CSRT followed its own procedures.
So there's no way to challenge the facts as reported by the Combatant Status Review Panel.
That's exactly right. So counsel in a DTA proceeding cannot present new evidence. You presume the evidence by the CSRT is correct. So in this case,
and that's as if it was an irrebuttable presumption.
It's fixed in fact and cannot be contradicted by any objective fact to the contrary. So in this case,
let me take advantage of the fact that there are 5 attorneys before me. Do any of you consider that to even in any way reflect due process? Colonel Abraham?
Sir, if I may, as a member of the CSRT panel, panel 23, that found the, as a member of tribunal panel 23 that found the detainee that was subject to that tribunal not to be an enemy combatant, a panel that was overturned a few months later, not only do I as a lawyer not find that to comport with due process, but at the time of our hearing, we did not accept those presumptions as irrebuttable, a position that was not shared in the vast majority, if not all, but a few of the CSRTs.
Colonel Abraham, I'm going to ask you to exercise some restraint. I really want to get to you because you have, as the saying goes, the inside view of this process. And that does not necessarily exclude consideration of a hybrid court, if you will. I just want to go back to the issue of association. And if we could swap once more, Mr. Azmy, with Mr. Salzmani. I want to be clear. If the standard is support individuals and organizations hostile to the U.S., does this incorporate the necessity to find an awareness on the part of the individual?
No, under the enemy combatant definition used as part of the CSRT, mere support is enough. There need not be knowledge, there need not be materiality, and there need not be intent. And you don't have to believe me, the government conceded as much as in part of this litigation when they conceded that hypothetical example involving a little old lady from Switzerland. And
the little old lady from Switzerland. Tell us, please, about the little old lady from Switzerland.
Suppose she writes a check to what she believes is an Afghan charity that turns out to be a front for the Taliban or Al-Qaeda. Could this person be an enemy combatant under the definition used in the CSRT? The government has said yes, because there is no intent or knowledge requirement. Could this woman be taken to Guantanamo? Judge Green asks. The government says yes.
So it's the government that's saying yes in this case?
Absolutely, and the answer to that question had to be yes. At the time that this hearing took place in December of 2005, the United States had rounded up hundreds of people who were legally, if not physically, little old ladies from Switzerland. So necessarily, and they had justified their detention. So necessarily, the answer to that question would be yes in the bizarre CSRT legal regime.
Well, I want to thank you, Mr. Azmy. I certainly want to thank Mr. Kurnaz. Let me echo the statements of all that have spoken relative to your particular situation. And I wish to convey to you, sir, that while recognizing what you've been through and the experience that you have had, please know that the American people are a good people, a moral people, and take pride in what we stand for. Sometimes there are occasions when our rhetoric does not match our deeds. But here in our government, under our system, we work diligently to redress the wrongs that we perpetrate. And we are not embarrassed to say that we made mistakes. That's what being an American is all about. That's what being a true patriot, an American patriot, is about. Yes, we are human, we do err, but we will do all that we can to rectify the mistakes that we have made. And I'm going to excuse Mr. Kazan and thank you so much for your participation today. It was very revealing. And now I'm going to...
Mr. Chairman, could I ask one question?
Sure.
Is the witness aware of any recording, whether it be a transcript or video recording, when he was told, for example, to sign papers that he knew were untrue under threat of further punishment and indefinite detention? Is there any evidence that we have, that there is evidence exists that this took place, or was it all in a secret proceeding, unrecorded proceeding?
Mr. Azmy, if you or Mr. Kazan could respond to Congressman Moran's question, if you're aware.
I am sure there are many filmings about those things, but I don't know if they did destroy it after or not. But there was in the interrogation rooms there was cameras, but I don't know if those cameras did work or not. If there was if they did took filmings about it or not, but there was cameras in the room.
So there were cameras in the room. You just don't know whether they were recording or not. Well, that's interesting, Mr. Chairman. There may be evidence available that corroborates this testimony, and obviously we have every reason to believe it, as does the German government. Thank you. I'm sorry for the interruption, Mr. Chairman.
No, thank you, Mr. Moran. And Mr. Kurnaz, once more, thank you for your participation today. We will excuse you from this hearing along with your outstanding attorney, Mr. Azmy. Thank you. And Mr. Daka. Vielen Dank, ja?
Ja, vielen Dank.